Welcome, everybody. We're here to talk about change and continuity on the Supreme Court, specifically in light of Justice Ginsburg's passing and the implications this has for the presidential election this year and just in general, the American political landscape. So we wanted to start by giving you an overview of her life and legacy. Justice Ruth Bader Ginsburg was the second woman appointed to the Supreme Court after Sandra Day O'Connor and will forever be remembered as a legal icon and chief architect of the legal fight for gender equality. She served as a Supreme Court justice for 27 years. Prior to Ginsburg's appointments to the United States Court of Appeals for the District of Columbia Circuit in 1980 and the Supreme Court in 1993, she was a master's student, professor, and litigator. At Harvard Law, she was one of 9 women in a class of over 500 and was asked by a dean why she was taking up a space that could have gone to a man. Despite facing adversity at school and at home, her husband, Marty, had been diagnosed with testicular cancer and she was raising a toddler. Ginsburg excelled academically. After making the Harvard Law Review and graduating from Columbia Law at the top of her class, she co-founded and became the director of the ACLU's Women's Rights Project and successfully argued 5 cases before the Supreme Court in the landmark litigation campaign launched during the 1970s. At the time, she was crafting her arguments for gender equality before an all-male bench. These cases tackle discrimination against men and women on the basis of sex and serve as the foundation of the gender equality jurisprudence that still endures in the nation's highest court today. Now, because of Ginsburg's legal strategy in the 70s, the Equal Protection Clause of the 14th Amendment is applied to sex discrimination. During her years as a Supreme Court justice, Ginsburg became an active dissenter. She was quoted on this, saying, "Some of my favorite opinions are dissenting opinions. I will not live to see what becomes of them, but I remain hopeful." In Shelby County v. Holder, the court made a decision that opened the door to voter suppression by eliminating the pre-clearance requirement of the Voting Rights Act. Justice Ginsburg's dissent articulated the following: "Throwing out pre-clearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you are not getting wet." She also dissented in Bush v. Gore, a case defined by its willingness to broach a political question. Ruth Bader Ginsburg is not only a feminist icon, but a Supreme Court justice who will go down in history for her dedication to the fight for equality. Now I'm going to do some introductions for my fellow moderator, Ben, and Professor Bottery, who will be leading this discussion tonight. So Professor Bottery is an assistant professor of political science at Gettysburg, and he's also an expert in public law and judicial politics. He has been published in many peer-reviewed journals and has also been cited in political science, economics, and law journals, including the Harvard Law Review. Politico, The Washington Post, USA Today, and The Hill have also published his op-eds. The other moderator this evening will be Benjamin Ponce, a 2020 graduate of Gettysburg with majors in political science and public policy. During his time at Gettysburg, he served as the editor-in-chief of the Gettysburgian, and he is currently a Fulbright postgraduate scholar at the University of Manchester. With that, I'm going to hand it over to Ben.
And of course, we're also joined by Anna, who holds a highly important and illustrious position on campus as editor-in-chief of the Gettysburgian, in addition to being an Eisenhower Institute undergraduate fellow. We're happy to take questions throughout this event. This is not going to be one of those events where there's talking at you for 40 minutes and then, a distinct breaking point, and then we go to questions. So feel free to start firing questions and we'll start firing them. And in the spirit of firing questions, let's start with this one. Maybe we could just set the stage a little bit, Professor Bottery, with a little bit of history. How did the comparatively staid Supreme Court of, say, the first half of the 20th century become the politically charged body with charges of anti-democratic features, certainly counter-majoritarian features, but some would go so far as to say anti-democratic features? How did that staid body of the 1930s, where they accidentally confirmed a Klansman, become the Supreme Court of today, where every time there's a vacancy, we seem to have a 5-alarm democracy fire?
There's a lot going on in that question, Ben. My goodness. So what I always when I start talking about American politics in general, I always like to point out that, we're not meant to be a true democracy in the literal sense of the word. We're a representative democracy, and a watered down one at that. And the way that our system is watered down is, through three things: the Electoral College, which we're all familiar with, the Senate, and the Supreme Court. And I wouldn't be doing a good job as a judicial scholar without mentioning some of the founding debates that were going on at the time of the ratification for the Constitution. If I can, I want to share my screen with you all. This debate here. So at the time of the framing of the Constitution, we needed 9 states out of the 13 to ratify the proposal, and New York in particular was kind of iffy. We weren't sure if we were going to get New York to ratify the Constitution. And so this is where we get the famous Federalist Papers. I'm sure we've all heard about them. The best one out of all of them, if you ask me, is Federalist 78. This is written by Alexander Hamilton, and it's one of the few that deal with the courts. This gentleman here on the right is Robert Yates. And now there's some debate about who the anti-Federalist actually was, but for the sake of argument, we'll go with Yates for today. Yates is from New York, and he has a problem with the court, and he comes out in public, publishes an anti-Federalist paper in several newspapers explaining why he has a problem with the court. And one of the things he highlights, again, this is, more than 200 years ago, before the Constitution was even ratified, was that there needs to be a better removal mechanism. Life tenure for these judges is dangerous. What happens if want of capacity should occur? There's just a whole slew of problems, Yates says, and this is when Hamilton jumps in and responds famously in the 78th Federalist paper. And he says, well, hang on a second. So these are going to be men of virtue. They're going to be bound by precedent. This is the weakest branch of them all. They're going to be, they have neither the purse nor the sword, which is possessed by Congress and the executive respectively. And he wins the day, right? They convinced New York to ratify the Constitution. Fast forward to right now, we're seeing the intersection of all three of those watered down mechanisms that I spoke of kind of at play here. And I think my supposition to you for this talk is that this debate right here, 200 plus years ago, is as relevant today as it was then. Because what we have right now in front of us is an executive who was elected by the Electoral College, but lost the popular vote. And we have the Senate, who has the majority senators are Republicans, but they represent a minority of citizens based on population. And they've now, this will be their 3rd seat in the Trump administration to appoint to a lifetime term, which can be, as far as a time horizon is concerned, obviously that's better than a 4-year term in the White House or even an 8-year term. So the policy implications of this is far reaching. And so we're seeing, dramatic pushback in the media, in the public at large, from the opposing party, the Democrats, saying this isn't right. We need to change something. We need to fix it, right? The interesting thing I kind of want to point out, and again, I want to reiterate what Ben and Anna have already said. If you have questions, please send them through the Q&A feature. I would be happy to handle them as they come in. I saw a chart recently, I think it was a day ago, saying, well, this is no big deal because this has happened in the past. Supreme Court nominations and vacancies have occurred in election years, and it's happened 22 times or something like that. And I was looking at the list because I was a little struck by the number. And almost all of them happened before the Senate and its battle turned into what we know it to be today. And with that, I just want to point out that these confirmation battles, they didn't even begin until 1939. So we probably have grandparents that were alive back then that are alive today that were alive back then. This is a relatively new thing. Before 1939, these were not very contentious. They were mostly done in voice votes on the floor. Those in favor say yay, those in favor say nay. The yays have it, the justice is confirmed. And one of the reasons why they started having public and transparent nominations, hearings about these nominations, is because, as Ben said, there was a Pittsburgh Post-Gazette piece published that said, hey, Senate, you just confirmed a Klansman to the Supreme Court for life tenure. And the Senate had egg on its face. It looked really bad. And from that point on, the Senate decided to hold these public hearings that we know now, where we have the nominee in front of senators answering questions, things like that. And the bipartisanship is also, or the lack of bipartisanship is something that's relatively new. Here at Gettysburg College, we like Ike, and here he is with two of his nominees who are confirmed. That's Warren on the left and then Brennan on the right, both of which are extremely liberal justices. Eisenhower had a few choice words about Warren at one point, but he did nonetheless nominate in a bipartisan fashion these justices. Things really started to change when this interesting looking fellow was nominated in the 80s. This is Robert Bork, and I'm sure you've heard his name because his name is turned into a verb, and that's always a really bad thing, right? Now judges can get borked. Just before Robert Bork here was Antonin Scalia's nomination, and Antonin Scalia was confirmed unanimously. Bork here was put up for a position that amounted to a swing seat, and so the Senate pushed back and pushed back hard, even though Bork and Scalia were essentially, in terms of their jurisprudence, the same justice. Conservative, had certain originalist principles. One was nominated unanimously, one was borked. And the data play out also. So here we have the interest groups activity pre and post Bork, and it's remarkable. It's 2-to-1 opposed post Bork, and this is kind of the atmosphere that we're living in today. Today we're in this post Bork environment, and this is what we currently know to be our political reality. Here's an interesting piece of data. I don't want to spend too long on this, but I do want to point it out. There have been some interesting institutional rule changes in the Senate along the way. Before 1975, in order to invoke cloture, you had to have a 2/3 vote in the Senate. So you had to have 67 senators vote to break up a filibuster. And in 75, that changed. And after that, the threshold moved down to 3/5 of a vote, so 60 votes to end cloture. And what this shows here is the distance between the nominee and the president. And so if you're a president, you want to nominate somebody onto the court who's just like yourself, who would make decisions just as you would. But because of the two-stage game we have going on with the senators, that's not always possible. And so what we see is once the threshold is lowered to a 60 vote cloture rule, presidents are able to get justices onto the court who are a little closer to their ideal point, to their policy ideal point. And then finally, in 2017, as we know, the nuclear option for Supreme Court justices was invoked, and now it's just a simple majority. And with that simple majority, presidents, in this case, President Trump, because he's the only one that's been active under this rule, has been able to get justices who are almost identical in terms of policy. And this brings us to recent events. So it's a pretty interesting fact when you look at the history of deaths and retirements on the bench that before 1900, 2/3 of the justices passed away while sitting on the bench. And that's a remarkable number, 32 out of 48 justices. But since the Kennedy administration, there's only been 3, and they've been very recent. Chief Justice Rehnquist passed away during George W. Bush's presidency. Justice Scalia passed away during President Obama's administration, and it carried over to President Trump. And then just on Friday, Ruth Bader Ginsburg passed away. Why is that? Why is there the dramatic difference in before and after the Kennedy administration? And it's a law that was passed by Congress, and this law amounted to a pension plan for Supreme Court justices. And so what this plan said is if your age plus your years of service equaled 80, so let's say you're 65 and you've been on the court for 15 years, you can retire and receive full pay for the rest of your life. It's a pretty sweet deal. And so what this actually did is that it created an incentive for Supreme Court justices to kind of time their retirements with an eye toward the White House, because these are policy-minded actors, albeit in the judiciary, and they want their replacement to be someone similar to themselves. And so we see this rise in what we call strategic retirements, and there's some pretty good anecdotal evidence to it. Here's Justice McReynolds. He was one of the 4 horsemen that continually struck down pieces of the New Deal legislation. And he says here, it's a salty quote from an actual Supreme Court justice: "I'll never resign while that crippled son of a bitch FDR is in the White House." Whoa, this is serious. And it's coming from a Supreme Court justice. This is William O. Douglas. "I won't resign while there's a breath in my body until we have a Democratic president." He ended up passing away under President Ford, a Republican. Thurgood Marshall, after a contentious Supreme Court decision, some of the justices were upset, and they contacted Bob Woodward and offered him an interview, and he gladly accepted that interview. Here's Justice Rehnquist, says that justices have a slight preference to leave the bench under their own party. Sandra Day O'Connor, famously on election eve 2000, after CNN, she was at a party in Georgetown filled with political elites. After CNN called the election for Al Gore, she scoffed and went running out of the room and left her husband there, and everybody was staring at her husband like, what the heck just happened? And her husband said, well, she's ready to retire, but she doesn't want to retire if there's a Democrat in the office. And then, a month later, she was on the court for the court case, Bush v. Gore, as luck would have it. This is Justice David Suter. This is taken the night of Bush v. Gore, after it was decided. He's leaving the courthouse in this picture, and he was so upset with what the court had done in Bush v. Gore that he was ready to quit. He ran off to New Hampshire. Maybe it was Vermont. I can never remember. I think it's for New Hampshire. Ran off to New Hampshire and to his cabin, and somebody had to go get him and convince him that he should stay on the court. And he was convinced, stayed on the court for 8 more years, and retired almost immediately after President Obama was sworn in. And the data play this out, right? So we see that retirements, justices tend to retire when there's a congruent or like-minded president in the White House. And so that brings us to Ruth Bader Ginsburg. What the heck is the deal then? All of these publications back in 2012 were adamantly calling for her retirement, strenuously begging her to step down. If she cares about the court, she should step down now before the midterms in 2014. And she didn't. She said, no, I am good at my job. I'm going to keep doing it so long as I can do it. And she did it quite well for the remainder on her time on the bench. And so what's the difference between these strategic retirements and someone like Ruth Bader Ginsburg? And this goes back to the quote that Anna brought up to begin everything with. And that's that she took a lot of pride in her dissenting activity. In fact, it's what I call the voice of the minority. So when you're the voice of the minority, you have a role on the court in many ways, just like an institutionalist, to the same degree as the Chief Justice, you care about the court as an institution. And that's what we see. These dissenters who dissent at a high rate kind of ignore this idea of a strategic retirement. They find value in their role in the court, and they stay on for a long time. Just real quickly, I want to go over some current events. So we have, this is what the court looked like just before Scalia passed away. Scalia passes away, and court commentators say, you know, the good play for President Obama would be to nominate a centrist. And that's essentially what he did in Merrick Garland. The Senate gambled, you know, in spite of the polls, they gambled and said, we're going to push it. President Trump won the election, and Neil Gorsuch is placed on the bench. I should note here that what I have going on here is just an ideological spectrum in the traditional left to right fashion based on decision data. And so one good thing about studying the courts is that we have continuous data. It's almost like a feedback loop. So with every term, with every decision, we can update these measures and kind of reposition folks. You can see here, Justice Anthony Kennedy is in the middle. And then he decides to retire under President Trump, and we get Kavanaugh. And so if you look here, the closest thing to a swing vote is Chief Justice Roberts and Justice Breyer. Now with Ruth Bader Ginsburg's passing, you can see that the court is heavily favoring the conservatives, and especially if a new justice gets pushed through, it's going to be even more so. But one thing I want to highlight before we kick it over to questions is this idea of a polarized court, this idea that every decision is a 5-4. And I think it's certainly fair to say that you might expect that to be the case listening to the media and listening to politicians, but it's just not true. What we have here is the modal category is almost always 9-0. In fact, usually the 5-4 decisions, the number of 5-4 decisions that we could, you can count on your hands, you can count on your fingers, the number of 5-4 decisions we get. And even among these 5-4 cases, they're not always the traditional 5-4 block that we would anticipate. So I posit to you that the court is less polarized than the media say, and it's more politicized from outside actors, politicians, senators, presidents, and the media. Here's another quick snapshot of data, and what this is, it's all 9 justices and how often they vote with one another. So here we have John Roberts with Anthony Kennedy, Clarence Thomas, RBG, Stephen Breyer, Alito, Sotomayor, Kagan, and Gorsuch. And I just want to highlight a few numbers because I think they're eye-opening. So Clarence Thomas and RBG voted together about 2/3 of the time. 2/3 of the time they agreed with one another. RBG and Samuel Alito, 68% of the time. Roberts and RBG, 3/4 of the time. Sotomayor, the lowest one of this whole chart, Sotomayor and Gorsuch, 60% of the time. I don't think that's evidence of a polarized court, although I'm sure some might argue differently and say that the number should be a little higher. And the justices in general typically agree. I know this picture is going around, but it's one of my favorites. This is Justice Scalia and Justice Ginsburg traveling in India together. They view their disagreements in terms of judicial philosophy, not partisan politics. I think it's a lesson to be had here. These sort of political norms within the court are strong. Outside, I think the political norms are eroding.
Okay, so we have several questions that have come in kind of about the politics of the last week. So maybe to start, just kind of summarize where we are. There's a vacancy, and the last time there was a vacancy in an election year was in 2016. And at that time, President Obama nominated Merrick Garland to the court, and the Republican-led Senate by Mitch McConnell declined to hold a hearing for Merrick Garland and said that the voters should decide. And we're hearing a little bit of I guess you could say, some would call it hypocrisy, some would say there's a distinction, but that right now, the Republican-led Senate does not want to wait until after the election. The argument that they're making is that right now we have a Republican-led Senate and a Republican president, so there's no problem putting a nominee forward, whereas before there were opposite parties, and they said you had to go all the way back to the presidency of Grover Cleveland to find an example when an opposite party president got to nominate a Supreme Court justice that was confirmed in an election year. So with all of that said, give us a sense of where we are and kind of some of the historical arguments that are being made around the precedent of election year nominations. Is there anything in the Constitution that says that you can't nominate someone 42 days before a presidential election? Is this the breaking of a norm? We talk a lot about norms with the Supreme Court. Talk a little bit about that, and then we'll get into some more specific questions about kind of what might come next.
Yeah, there's no constitutional, there is no constitutional barrier to pushing through or nominating and confirming a Supreme Court justice right now, as close as it is to the election. Even in a lame duck period, it can be done. There's no, the Constitution does not forbid this. And yeah, I completely understand this idea of the claims of hypocrisy. I think there's something to that, right? I mean, it wasn't 3.5 years ago that we were, in the same boat. And we have all these senators on record then saying, oh no, we do the same thing if it happened again, and here we are. And they're finding, a workaround, whether that's, we control the Senate, and so does, there's a Republican in the White House. It's hard to ignore that, right? As far as norm violations, I think we've seen that across the board in American politics. And it's not something that's new to the Trump administration by any means. Harry Reid, a Democrat from Nevada, is the one who first went nuclear, lowered that threshold for the filibuster to a 50 simple majority vote confirmation for lower court nominees. Yeah.
So given that, then it's within the Republicans' right to put up a nominee and for the president to put up a nominee and for the Senate to try to confirm him. There's talk among Democrats that if Republicans do that, they're going to retaliate come January. There's this notion of constitutional hardball tactics, and maybe if you want to start by defining that term, but then also say a little bit more about kind of how the counter-majoritarianism that was baked into the Constitution was supposed to inculcate some kind of maybe virtuous cycle, and maybe right now seems to be inculcating a cycle that is, less virtuous.
Yeah. So repeat the second question, Ben, if you can.
Sure. Well, I mean, I think that we're in a moment that is, both sides are getting ready to take pretty dramatic steps. Yeah. Republicans are ready to take a dramatic step of reversing what they said they were going to do 4 years ago and getting somebody on the court to get this win before who knows what happens in November. And Democrats are talking about, maybe we're going to pack the court when the time comes. It seems like both sides have taken a hostage and are kind of waiting for the other one to blink. So I guess, how does this relate to a constitutional system that is set up to give minority parties some power, but also to ultimately allow for some of this majoritarianism that we're seeing?
Yeah, so this idea of constitutional hardball is actually really interesting. So, like I said, nothing in the Constitution that forbids this. It's more of respect for norms. And so constitutional hardball is you're honoring the black and white letter of the Constitution, and maybe you're doing things that are, disrespecting longstanding norms. We saw that happen in the Bork nomination. We saw that happen again with Harry Reid going nuclear for the lower courts, and then McConnell going nuclear for the Supreme Court finally to get Gorsuch through. And now, of course, we're seeing proposals for things like court packing. We're going to add seats to the court. Along those same lines, there's nothing in the Constitution that says that the Supreme Court has to consist of 9 justices. In fact, it's just a law from Congress that makes it so. And so if you have control of the political branches, you can push through a judiciary act that can increase the size. Famously, FDR did this, or proposed to do this in his fireside chats. And there was almost immediate public backlash. Folks did not like it. He did not pursue it further. And I actually get the sense that we're in a different spot. And I think it's because we're in a different spot today. So if that proposal was put forward, I think it would actually garner a surprising amount of support. And this is because, again, the president lost the popular vote. The senators who are putting forward this confirmation vote represent a minority of individuals in the country, and it's a lifetime appointment. So I actually think that these battles are going to get more intense down the road.
I guess kind of along those lines, we've gotten a few questions about court packing, if Biden wins, et cetera. But as you were talking about, that could likely be the erosion of a norm that's kind of been set in place, and a norm that people under FDR really didn't like. What has changed since then? Is there an entity? Is it like hyperpolarization of, the public? What has changed that makes court packing a more feasible outcome of the election?
I think it's the general sense from Merrick Garland's failed nomination, and then now this. I think that, again, these are outside actors that are turning the court and its workings. This is supposed to be a co-equal branch of government. This is supposed to be 1/3 of our government. And it's being treated as a slippery political football by the political actors here.
One concern that people have raised about court packing is that, say in 2021, Democrats will do it, and then the next time Republicans take control, they'll do it, and before long, we'll have a court of 55 people, and they won't all fit on one rostrum. I'm sure that's the primary concern. But what are some other reform proposals that are out there that might provide an off-ramp to that kind of escalation? I know one that you've written about involves 18-year terms for members. And I know there are some constitutional questions. Could that be done without a constitutional amendment? Talk a little bit about that, if you would. And I imagine we're about to get into some Article 3 minutia, folks, so strap in.
Well, Article 3 is very short, so I won't bore you too long, just simply because I can't. There's not much there. Historically, there's some historical evidence that says that the framers were kind of antsy to get back home, and they kind of gave up on Article 3. If you read it, it says that a Supreme Court needs to exist, and you can't reduce their salaries, and they have to serve while in good tenure. While in good behavior. And that has been translated to mean life tenure. It doesn't actually say life tenure. It actually doesn't even say judicial review if we want to get really technical about it. There's no mention of judicial review in the Constitution anywhere. So one of the proposals that's put out there is a constitutional amendment to bring back the filibuster, but on a constitutional basis. So to confirm a justice, you need 60 votes. And this harkens back to the original idea of the filibuster. The original idea of the filibuster was to foster compromise. And this kind of gets to Anna's question. So, why is this happening? I think it has a lot to do with the polarization in Congress, in the electorate in general. And that's translating now onto the court. Instead, what the filibuster slowly morphed into was, holding a seat hostage and just not doing anything about it. And so you get rid of it, and now you have a simple minority or majority vote. So that's one proposal. One proposal that I'm fond of is a staggered term of years. So an 18-year term. And I posit that there doesn't need to be a constitutional amendment to enact this. So again, what Article 3 says is that they have to they can hold their office while in good behavior. And so it depends on how we define the office. If we define their office as a federal judge, then what we can do is, let's say we take the circuit courts, the lower courts, the appeal courts, and we use that as our pool of candidates. And the nomination and confirmation procedure happens normally, but the president has to select a judge from the circuit courts, as I think most of the short list that Trump is currently looking at are judges on the circuit court. They elevate to the Supreme Court for a term of 18 years, and when they're done, they go back to the circuit court. So long as we don't reduce their pay, I think that's actually consistent with Article 3's language. And what we would have then, and this is why I like it so much, because this is not a Democrat or Republican solution here. What it is it gives voters a knowable, foreseeable event. So every time they go to the poll to vote on a president, that they know that that president, the incoming administration, will have 2 seats to fill on the Supreme Court. And so accidents of history, accidents of health are kind of taken out of the equation, and we see less of this political jockeying that we see now. And it hopefully can restore some of the legal norms that are supposed to surround the court. I was going to maybe pull up a graphic, but I don't think I will. It would take some doing. It would take a while to get in place such that each seat is staggered appropriately. But implementing it is kind of, I think it might be worth it, especially when the court itself is, its legitimacy is at risk, given all this political wrangling that's going on. Similarly, when the 16th Amendment was passed, this is the income tax amendment. And when that was passed, judges were taxed, and that tax reduced their salary. And so some clever federal judge said, hold on, this violates Article 3. You can't do this to me. And so the Supreme Court upheld it. They said, you're right, you can't tax federal judges because that reduces our salary. And then it took them a few years, but they reconsidered it. And then they finally said, you know what, you're right, you can tax us. And what they did was they slowly implemented that tax so that the judges who were on the bench pre-16th Amendment served out their years without being taxed. And the new ones who came in were subject to income tax. So glad to say now judges are also paying their fair share of taxes.
That's a relief to us all. We've had a couple questions, and I'm going to consolidate, and these questions all assume that the Republicans do confirm President Trump's nominee. So assume we have a 6-3 Republican appointee majority. There are 2 related questions. One is, how might John Roberts view that? He's been kind of the swing vote since since Trump's last 2 nominees have gone on the court. Would we see a situation in which he assigns him, votes with the majority and then assigns himself to write narrowly construed opinions so that, we don't erode more public confidence in the court? So that's kind of question 1. What would Roberts do? And then question 2 is looking ahead to what's on the docket this term. What are some of the possible implications of having a 6-3 conservative majority? And this questioner asked in particular about LGBT rights. I will just note as an editorial comment that it was, of course, President Trump's appointee, Neil Gorsuch, who voted to interpret Title VII back in the spring to include gender identity. So, sometimes justices surprise us. But what are some of the key cases that we might see have implications if the ideological shift of the court were to switch this term?
I'm actually going to add on to that, if that's okay, because I guess I'm just worried and wondering myself whether or not the justices themselves are concerned about judicial legitimacy, if it's Roberts more so than other justices, or, as Ben said, will Roberts assign himself a new role? Has he already assigned himself that new role? And will we be able to analyze this looking forward, or is the court itself just too insulated, and will the opinions not give us enough information to look at that more closely looking forward?
Yeah, I think we can always find a foothold into the opinion assignment it's going to get really messy if what you say actually takes place. So if the way opinion assignments work is if the Chief Justice is in the majority, he gets to choose who writes it, and he can choose himself. Now, if he does that, if he's in the majority and he chooses himself and he starts writing very narrowly tailored opinions, the rest of the voting bloc can defect and write concurring opinions and only agree on judgment, which as a matter of law and legal precedent, it gets really messy then. So what is the controlling opinion? So yeah, Roberts has a lot of sway here. And I think you're right to point out that out of all the justices, they probably don't care about the court's legitimacy to the same degree. And so this is a matter of variation, right? This is, and if there's anyone who cares about it the most, it's definitely John Roberts. John Roberts has proven himself time and time again in his position to be an institutionalist, just the same way Ruth Bader Ginsburg was. But she was in the dissent, right? So now she's gone. I also wouldn't be surprised if Roberts or the court in general issued some sort of statement about what's going on, because it's really getting to the point now where the court is just being tossed around. Yeah, and what it does with precedent, one of the issues that has come up in the media a lot is this idea of reversing Roe versus Wade. I can say that that's not going to be an issue this coming term. Some of the other hot button issues, there are a few police procedure cases. I don't think there's one, and I could be wrong about this, on LGBT rights. I'd want to double check before you quote me on that. It was most recently decided this past term. So yeah, I think all eyes are going to be on Roberts. With regard to Roberts, I will say, although he's the closest thing to a swing vote that the court currently has, looking at his jurisprudence, there's no doubt he's a conservative justice. It's usually a 70-30 split with him, if that. He just happens to be closest to that middle line that I showed you where the blue and red lines connect. The real epitome of a swing justice would be Sandra Day O'Connor. Sandra Day O'Connor was truly right there at that middle point, and it was a coin flip which way she was going to decide. But if we're going to read the tea leaves with Roberts, I think him joining the majority for the recent abortion rights case was pretty telling. And one of the reasons he said he did was because he needs to respect precedent. And they decided a similar issue just a few years prior. So again, I think that might be the best indicator of how he's going to handle things moving forward.
A couple of questions that relate to how this vacancy will affect the 2020 presidential election. So if you'd like to put on your political scientist hat a little more explicitly. Two related questions. One is about healthcare. I will say that I listened to several hours of NPR while on the road today, and because only Democratic senators go on NPR anymore, I got to hear several iterations of the new Democratic talking point that the key issue here is healthcare, and there is an argument slated on appeal from the Fifth Circuit this term about the Affordable Care Act and this question of whether the whole law will need to be struck down if the individual mandate is in fact unconstitutional when there's no penalty, so it can no longer be described as a tax, as John Roberts said it was in 2012. And then more broadly, do we have a sense of whether this issue is more likely to motivate Democratic voters or Republican voters? I know in 2016, there's a lot of thought that this was a motivating issue for Republican voters who otherwise weren't enthralled with Trump. But we also saw on Friday evening that Democrats raised just millions and millions of dollars in their small dollar platform in the hours immediately after. So do we have any sense yet on how that's going to shake out?
Yeah, it'll be really interesting. Part of me wonders, if I'm going to just put on my political science hat, Ben, why not leave the seat open until the election? That's really going to drive voters on both sides of the aisle, I would think. But yeah, I think it is going to be a mobilizing factor. I think it's not only, what's happened with Merrick Garland and now and now Ruth Bader Ginsburg, but it happens to be Ruth Bader Ginsburg's reputation, both culturally and as a legal scholar. I mean, so one thing I will say about Ginsburg is that her reputation is well deserved, whether you agreed with her or not. If you disagreed with her, her opinions forced you to do a better job. They were just whip smart. And culturally, we all know the notorious RBG, right? And so I think that impact is going to actually matter. But we'll see. This is a testable hypothesis, as political scientists would say. But with regard to healthcare, I forgot about the healthcare case. Roberts is going to have to do a pretty fancy two-step to avoid his original decision in the ACA case of 2012. This is the one where, everyone was arguing for the government that it's a penalty, and then they decided it is in fact a tax. And now that it's not there, it's going to be really interesting to see how he kind of balances that. I can't foresee it, so we'll see. I mean, my goodness. If the Supreme Court decides on this, it's going to get kicked back to the states for the states to have some sort of health care within their state boundaries. I always like to think the states as policy laboratories rather than federal nationwide policy. States can often implement policies that seem really appealing and actually draw residents to them. We see that happening in various subject matters. Healthcare.
Briefly ask a quick follow-up to that healthcare question. The new Democrat talking point is that pre-existing conditions are going to be decided by the Supreme Court this term. I mean, certainly it seems the way that would happen is that the whole law would get struck down after the individual mandate, which is what is in question, would get struck down. Do you see that as a likely scenario?
Yeah, I think it actually poses an interesting question of law too, because you rely on a law and you're injured because as a result of it. It gives you standing before a court of law. I would imagine that the court would probably slow walk this. One thing about the Roberts Court that's a little unusual is the pace with which they're accepting these appeals. Normally, it would be the case that a controversy would happen in the state, and it would take 6 to 7 years on average for that case to elevate to the Supreme Court. Now that's just not the case. Now we're having controversies, and the court is hearing them the very next term, the very next year. It's actually an exponential rise in the pace of acceptance. So we'll see. I don't think I have a clear answer on that, but I think it does pose an interesting question of law, that's for sure.
We also have a question about the 18-year term limit proposal, and whether or not you think that 18-year term limit proposal, if it actually is something that the court proposes, or sorry, not the court proposes, but Congress proposes, will fundamentally move the Supreme Court in the direction of being a more democratized body. And then the follow-up question of, if it does move it towards being a more democratized body, is that even a desirable outcome?
Yeah, so one of the things that I like about the proposal is that it kind of satisfies both Alexander Hamilton and Robert Yates, the very first picture that I showed you. It satisfies Yates because we have some turnover, and so Yates's point about want of capacity, what happened, what do we do if that should arise? We don't have to worry about that anymore. But it satisfies Alexander Hamilton in the sense that the reason he wanted the Supreme Court to be so insulated was so that they could make unpopular decisions free from the whims of the majority. And with this, they're still serving for life. It's kind of more of an act of service to the judiciary to rise up to the court, serve that term, and rise back down. Who knows, they might want to retire after that. 18 years is a long time. But yeah, I think it satisfies Hamilton in that sense, is that they're still not threatened with being removed from office by a vote, by the ballot box. They're still appointed and they're there. They have that job. They have that pay. It's just a matter of which bench you sit on. And I think from that sense, it satisfies both of them. And that's one of the reasons why I like it.
Pivoting maybe to a little bit of a bigger picture democracy question, one way you could rephrase that question we just asked was, is more democracy good for democracy? But in a similar vein, there were a couple of Harvard professors 2 years ago who wrote a book called How Democracies Die. And they assert that there are these kind of two fundamental tenets of democracies, liberal democracies, that survive. And those are toleration for the other side's right to exist, and this thing they call institutional forbearance, which is avoiding playing the constitutional hardball that we were talking about earlier. So examples of that constitutional hardball being packing the court with additional seats, or not holding a hearing for a justice nominee, you could say. I guess the question here is, what might political actors or concerned citizens who are interested in finding an off-ramp to this kind of escalation that we have seen over the past couple decades relating to the Supreme Court, what might those political actors or those concerned citizens do or advocate for that would help inculcate some of those traits, like toleration for the other side, and not playing hardball every election, every time there's a Supreme Court seat, et cetera?
Yeah, and I think just as a general matter, I think we've seen an erosion of civil discourse in the country. I think that's been pretty apparent. We have these polarized sides now where, I don't know about you, but I can't remember. One of my biggest complaints about, the past 5 to 7 years is I really can't remember the last time we had an honest to goodness policy debate about where one side presented their case and they had a debate about its merits and its shortcomings with the other side. I think that's a point of, again, like you said, big picture, our civil democracy here kind of eroding away. I would rewind back to Justice Black being discovered to be a Klansman, right? The reason the Senate started holding transparent and public hearings was because of the public's backlash to that. Hold your agents accountable. Your agents are the folks we send to DC. They're our agents. We're the principals. The system is designed for us to tell them what to do. And so it might sound a little quixotic, but I do think that it's worthwhile. So voicing the displeasure with the state of things is important.
Definitely. Kind of to go back to that idea of court packing, or more broadly, kind of, I guess that could be considered an erosion of a norm that we've established. But is there any reason to think that if we kind of open that can of worms when it comes to court packing, will it ever be closed? Will it increase the politicization of the court? Will it balance things out? Will justices feel some sense of responsibility to play by party lines and their opinions? How do you see all of that playing out?
I think it absolutely would increase the politicization of the court, and I think it is an awfully slippery slope to go down. I also understand the urge to want to do that. I completely get it. There's nothing stopping it. The court size throughout its history has fluctuated from 5 to, I think it even had 10 members at one point, right? So it's just been at 9 for a long while. But throughout its history, 5, it had 6 for a long time. Eventually it went up to 10, but it's settled at 9 for quite a long time. I actually think there is merit to having an even number. I think that actually really spurs the justices on to try to bargain amongst themselves, which is always a good thing. The deliberative process it works. We should see more of it. Again, we're just going back to the same idea of these erosion of norms. But yeah, I think it would be a slippery slope, probably impossible to turn off. You can kind of see parallels to that with the nuclear option. When the nuclear option was being proposed by Reid, McConnell said, "You're going to regret this." There's video of him saying this, and sure enough, here we are.
So let's do a couple of rapid fire questions, and I'll promise that I'll keep the length of the question short, and maybe you can keep the length of the responses short as well. But first, mandatory retirement ages on the Supreme Court, good idea, possible? Should we have a lot of octogenarians deciding these cultural questions?
I once wrote a manuscript. The tentative title was Shrewd Octogenarians, and it was about that retirement spiel. I think it's completely possible. States do it. Again, these laboratories of policies, some states have that. Yeah, that's one possibility for sure. But again, the idea is to keep the court fresh, and we're going back to the anti-federalists here. You know, again, I made the supposition at the beginning that that debate is relevant today. Here it is again. It's finding its way back up into all of these policy debates.
Any guess as to who the next Supreme Court seat to open will be and when that will happen?
Oh, so
that depend on the outcome of the election, like the next seat after Ginsburg?
Yeah, so that's tough. Some people, I've heard rumblings that, oh, wouldn't it be nice if Roberts like sacrificed himself to even
I've
think
rumbled that.
Oh, I knew it was a silly idea. I heard it somewhere.
Yeah.
So Roberts is young. Thomas is 72. Breyer is 82. Alito is 70. Sotomayor is 66, and the rest of the folks are relatively young. Thomas doesn't strike me as being all that happy with his position. I think he's even said, he's staying on to, piss off the people who gave him a tough time during his confirmation battle. So, I wouldn't be surprised. My money would probably be on Breyer or Thomas.
And then one final rapid fire question. Is there a sense of urgency to fill this seat now, given the possibility of having a case arise out of this election that needs to be litigated before a full court? I know that when it was 4-4, when there were 8 justices, some of the justices themselves said it's not great for the court not to be at full strength. Is there a need to get it to 9 in time to litigate those things? Or in the contrary, would having a Trump justice on a new Trump appointee on the court make that worse?
Yeah, so Bush v. Gore II, a nightmare scenario, right? We have Bush v. Gore II, and it's not even a full court, or if it is a full court, it's full because of a contested confirmation. I will say Bush v. Gore, they say in that opinion that you can't use this as precedent. So I want to see what they pull as precedent if Bush v. Gore II comes about. So that'll be interesting. Yeah, I think it's a problem. But I also think that having an even number, let's say they just had 8 justices, well, I mean, it would still probably have a winning outcome given the ideological block. So that being 5-3.
That final question for the evening, I suppose. Putting on your prediction hat again, we talked about John Roberts being an institutionally minded actor here. You're John Roberts. You see the court kind of in this politicized mode, questions about its legitimacy proliferating. What do you do over the next 12 months to try to build more public confidence in the Supreme Court?
Yeah, I really, I would not be surprised if John Roberts went public, made a statement. And I say that because normally that's a very rare thing for a Chief Justice to do. But he's come out strong against Trump's Obama judge, Bush judge, pejorative connotations that Trump has been using toward the federal judiciary. He's been awfully vocal, at least in terms of, comparatively speaking, to past history of Chief Justices. So I wouldn't be surprised to see him take a stronger stance, issue a strongly worded memo, as lawyers do. And after that, his voting behavior. I think if we've seen anything, especially this last term, we've really seen an amplification of his concern for the court, deciding very narrowly or even concurring on a few decisions to give a win to a particular side. I think, there are some principles he won't budge on, but I think that on lots of the issues, particularly some of the hot button issues, I think that I wouldn't be surprised to see him moving over and I don't know, for lack of a better term, helping the other side.
When I said that was the last question, I lied, because there was one I forgot in the rapid fire round. We had a question about Ruth Bader Ginsburg's kind of last public statement that was dictated through her daughter about her most fervent wish being that the next president would replace her. of course, kind of baked into that statement is this idea of these seats being, I don't want to say hereditary, but that it's her seat at this point. Do you think it's a good idea to think of seats in that way? Should we think of this as being Ginsburg's seat that's being filled, or should we think of this in some other way?
I think of him that way. So Ginsburg's seat, funny enough, became open because of Byron White's retirement. Byron White was a JFK nominee, a Democrat, and Byron White during his entire career ended up being fairly conservative. And Kennedy, before he was killed, said, "Man, I regret that decision," or something to that effect. And so Byron White wound up being a conservative for his entire tenure, but he's the only instance, when I was talking about strategic retirements, he's the only instance of a justice feeling the desire to hand his seat back to the party of the nominating president. And so he actually said this, we have historical record of it, and he gave the seat to Bill Clinton, and Bill Clinton then nominated Justice Ginsburg. I certainly view seats that way. Justice Thomas is sitting in Thurgood Marshall's seat. Chief Justice Roberts is sitting in Rehnquist's seat. I think it's really cool. One of the reasons why I like this particular topic is because it's kind of at the intersection of history, politics, law, behavioral economics. So that's what drives me to it. So.
And White may have thought that way, but certainly I think Republicans would be happier campers if John Paul Stevens or David Suter, some liberal justices who were appointed by Republican presidents, thought in the same way. So I guess, it's all a little different. I think that's going to conclude tonight's event. So with that, thanks for attending, and hope you enjoyed tonight's conversation, Change and Continuity on the U.S. Supreme Court.